Get ready for the dictation. Start. Over 75% of India's prison population are under trials, while overcrowding in Indian prisons stands at 118%. These stark realities are often cited to represent the scale of the crisis in India's criminal justice system. The Supreme Court of India recently acknowledged in Satyendra Kumar Antil versus CBI the ineffectiveness of India's bail system and its contribution to this crisis. The court noted that despite repeated guidelines on bail law, things have not changed much on the ground. The court provided comprehensive guidelines on laws related to bail, such as mandating timelines for the disposal of bail applications and laying emphasis on the need to enact a separate legislation. The judgment noted that crowding jails with under trial prisoners ignored the principle of presumption of innocence and that bail not jail should be the norm. However, there is still a need to reflect on why these established principles are honored more in their breach than observance. Any reimagination of the law on bail needs to first understand the exact nature of the problem that results in large scale under trial incarceration. This assessment needs to be based on multiple parameters, and we have no real empirical evidence on how each of these impacts the issue. What proportion of under trials are applying for bail? What proportion of bail applications are accepted or rejected, and on what grounds? Is bail compliance a far bigger problem than denial of bail? These are some fundamental empirical questions which need answers. An effective bail law must be based on the correlation of these answers with variables such as the demographics of under trials, category of offenses, and timelines for bail, and also address socio-economic and structural barriers. The foundations of the current bail law ensure that it is anti-poor and disproportionately burdens those from marginalized backgrounds. The solutions are intended to craft must be based on a deep and realistic understanding of the problem. The court averred that effective enforcement of safeguards against arbitrary arrest would eliminate the need to seek bail from courts. However, these safeguards exclude a significant proportion of arrested persons, especially those from disadvantaged sections of society who form the large majority of under trial prisoners. For example, the arrest of a person is justified as necessary if the police have reasons to believe that it is required to ensure their presence in court. Such vague justifications put migrants, persons without assets, or those with no contract with family at higher risk of arrest because of their socio-economic conditions. Data from the Fair Trial program in Yerwada and Nagpur Central prisons can be instructive here. Of the under trials represented by the FTP, 18.50% were migrants, 93.48% did not own any assets, 62.22% did not have any contact with family, and 10% had a history of previous incarceration. Evidently, a significant proportion from the sample would be unjustifiably excluded from protections against arrest and contribute to the large proportion of under trials in our prisons. The power to grant bail is largely based on the court's discretion and depends on the facts of each case. The Supreme Court has time and again laid down principles for guiding the exercise of such discretion by courts in deciding bail applications. While these guidelines lay stress upon the need to release applicants on bail, they also validate the denial of bail or imposition of onerous bail conditions based on the gravity of the offense, character of the accused, and likelihood of the accused absconding or tampering with evidence. In all such cases, courts rarely exercise their discretion for granting bail and are likely to take a more stringent approach against release on bail. Despite existing guidelines, courts do not usually record reasons for rejecting bail. The rationale behind how courts factor in offense based and person based considerations in deciding bail applications remains unclear. This is important because marginalized persons bear the brunt of these broad exceptions. They are either denied bail or granted bail with onerous conditions in absolute disregard of their realities. Bail conditions in the nature of cash bonds, surety bond, proof of property ownership, and solvency, as is commonplace, are at odds with the reality of under trial prisoners languishing in jails. Stop.